The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can see our program on Mediacom Channel 15 on Sunday afternoon at 1 o'clock, and again it's repeated on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. For the parents out there that are needing help with um, losing their children to the DHS or getting an abuse report written up against them, we have experience to give you some thoughts. We're not attorneys. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. That's the main issue that we focus on, and there's a couple of missions that are involved in that. One is to influence public policy as it relates to child protection issues. And secondly, we strive to assist people. Though we're not attorneys, we attempt to give some hints as to the best way of attacking a problem that you may have with the Department of Human Services, an ever-expanding department. I thought they had hit their peak in the number of what I call ticket writers, social workers who do nothing but work on child abuse reports, when they had 204. That was their high when Shelby Dewis was killed. Well, and of course they've never found the murderer, and they were never able to protect the child. But they had lots of ticket writers out there at very expensive salaries. Now they have 214, as we'll see in one of the articles, 214 social workers out there in the field, backed up by all kinds of office staff and supervisors and administrators and managers and all kinds of individuals who can support this marvelous system of child protection. The only problem is they're not protecting children, are they? So there's a lot of activity going on. I can promise you that. I looked at even if I took a very, very low salary figure of $42,000 a year and multiplied that times 214, it comes up pretty close to $9 million just in basic salary. And you can bet that there's about 1/3 of the salary costs you can add to that for benefits. So that's a lot of money, isn't it, for just one service position in the Department of Human Services. They're called social worker 3s. And now they all have to have baccalaureate degrees. They've increased the qualifications for social workers. However, I've not seen that increase in the actual qualifications of the people that they actually put on the payroll. Some of these people are not all that swift. They probably have been unsuccessful in finding jobs elsewhere, so they can make a social worker out of them. Because apparently they don't need a whole lot. Now, when I go through the materials and the manuals and so forth, it looks like to me it would take a pretty bright individual to sort things out properly. But do they do that? I rather doubt it.
Maybe that's because they're not bright individuals.
That's right.
That's been my experience anyway.
Right.
I'm not talking about all of them, but the ones I've dealt with.
There are some, but the ones that are good stand out because they're something remarkably different from the others in the group. There are some pretty wise social workers, and even some of the older ones, I think, with a lot of experience, could help out if they didn't have their hands tied and if they weren't told how they were to do things. We talked to one gentleman who sent his daughter through the University of Iowa. She got her degree in social work at the College of Social Work down there in Iowa City, and came home, and I think she took a job for just a short period of time. And
6 months.
well, I think it was 8 months actually. And he said, "Why did I put out this kind of money for you to go to school only to come home and not stick with a job longer than that?" She said, "Well, they teach me one thing at school, and then when I get on the job, they tell me I have to do it a different way." Well, that would be a little disconcerting, wouldn't it, if they trained you to be a social worker, and then when you get on the job, they have
Destruction worker.
a different way.
Destroy the family.
Yeah, by all means.
Socialist worker.
Social, that's what I call it. Well, those things are frustrating. I've run into a number of cases with grandma and grandpa cases. 100 years ago, if there was any problem in the family, no difficulty, because grandma and grandpa would solve any problems that existed between the younger folk, and aunts and uncles would come in to support. But today I heard a strange story where a father tried to step in and take his little baby out of a terrible, terrible situation. And the police took the baby away from the father and put him in foster care. Well, you know all about that, don't you, Terrance Walker?
Yeah, I was about to say, that sounds awful familiar there.
I think your baby was like 14 years old, though, wasn't
Yeah,
it?
she's 13.
She's
And
13.
The funny thing is that the foster care people, or none of the people that were involved, actually notified me before they were put into foster care. Before my daughter was put into foster care for about 4 or 5 days, and I had to find out through third party where my daughter was, and then on top of that, I had to deal with the temporary foster care lady in the court. She happened to, for some reason, went into the court when I filed for temporary custody, and was trying to represent the mother, but I told the court this was between the mother and the father. This had nothing to do with the temporary foster care placement, because I was a legal custodian of my daughter. And I just find it odd that they're supposed to notify you if you have joint legal custody, especially of your child. I found it odd that they never did notify me that my daughter was placed in a temporary foster care place for those 4 or 5 days. But,
I think they're
like I said, they're not all that bright. Some of them are not all that bright when they follow those regulations that they're supposed to follow.
Isn't it the elevator doesn't go all the way to the top?
Well, I don't think
one brick short of a full load.
Or was it a hamburger short of a Happy Meal?
Right.
I could think of a dozen of those right now. Yeah.
Is that right?
Yeah.
The assumption that they're operating on is one that we've discussed on this program, and that is the grass is always greener on the other side of the foster fence. In other words, the best thing that the department can do is to remove the little child from the immediate family and from all other influences, such as relatives. That way they have full control over the person who is taking care of the child. You see, Granny is likely to let the young'uns come and visit the baby. If DHS doesn't want that to happen, DHS can tell the foster parents no visitation. In fact, you may not even know who the foster parents are Furthermore, you'll not know where they live. So we'll develop a secret society such that you cannot get access, appropriate daily access to your own children, because that might upset your children. And I've heard parents going on for a few days to a few weeks to a month, and sometimes even longer before they even get to see the children, because there's another fallacy they go by, that the children don't need to be upset by seeing their parents after they've been taken out of their familiar surroundings. They give them new clothes, they have a new house, and in some cases they tell the kids that they have to call their new parents mom and dad, which I think is very, very destructive. But they do it anyhow. You were lucky enough that you could come against them there at least a few days after and rescue your child, right, Terrance?
Yeah, I just went and got her from school. So I had that right. You know, I was on the paperwork at her school that she went to that said I could pick her up. And since nobody notified me of anything, there was nothing that they could actually accuse me of, because I don't know what's going on. I'm going to get my daughter from school.
And your daughter was very happy to go home with you.
Oh yeah, she was more than happy.
Did she like the foster home?
Well, she said it was nice and all this, but you know, it's not like nothing like family, nothing like being home with, you know, your own. You know, and you know, I find it odd that after I rescue my daughter out of this situation, I somehow turn into a bad guy in the eyes of one of the grandparents. So, you know, it just, you know, interesting situations. And, you know, if the grandparents were so anxious to have the granddaughter, they shouldn't have let her gave her up to the temporary foster care in the first place.
Did they actually support the foster care stay temporarily?
I don't know. I think they just were under the impression that they had to give her to foster care for that period in which the mother was incarcerated. And
The ignorance.
yeah,
Most people are
and you
ignorant
don't
about
have
what's
to. I
going
mean, I
on.
read the law, and it says that when the arresting officer takes a child that's of the parent that's been arrested, they're supposed to find an immediate relative and place the child there temporarily. Or, you know, it shouldn't go to the grandparents and then to foster care. If there's no immediate relatives available, then it's supposed to go to temporary foster care.
Correct.
However, they went to the grandparents and then to temporary foster care, which I thought was just totally insane, especially since they didn't notify the other legal custodian of the child, which is their father, me.
In your case, we're talking about the child has been living with your ex,
Right.
and the social worker grabbed her without probably your ex's knowledge, and so you stepped in and got your daughter.
Exactly. Well, I think the mother knew what was going on, but she was
Not enough.
Well, she probably didn't understand the full legal ramifications of what was going on. But you know, I think her reasoning might have been that, well, I want my daughter at my grandparents, but somehow she got to temporary foster care. So I don't know what she did, but I think she signed over her rights temporarily, which should not diminish my rights because I'm a legal custodian, and that's what I argue when I went and got temporary custody. So it's just a weird case, and like I said, you know, at the beginning of the show, not all these social workers know exactly what should be done in these situations.
That's right.
So we need some more training.
I'm
Definitely.
not sure that would really help, because they sort of develop their own agendas.
Yeah.
And there's no training that would be really good for a social worker who develops their own on the fly. So
Yeah, it's pitiful though.
Luckily, your child was 13 years old, and they have some kind of ability to brush off problems and changes in their life and so forth. They can roll with the punches, but I don't think an infant is fully equipped to understand why mama isn't there, why father isn't there, why there's a strange place, strange crib for him to sleep in, and why the noises are different, and why there's other kids in the home that he didn't know about, didn't approve of, why there's different animals around and so forth. So these children are impacted tremendously, and they really don't care how many times they have to shift a child from a familiar background to some foster care placement. They don't even do that. They don't move pigs totally without some consideration. They certainly don't move them, do they, Don, on when there are storm conditions, because it wouldn't be the right thing to do.
But on the other hand, humans with cats or animals, as you were saying, pigs, they wean them at a very early age. And DHS is the same way. They love to grab the babies, don't they?
They sure do, because they're marketable.
And that means money, money, money.
Yeah.
Not to the family, not to the child, to the system, the DHS.
It's absolutely right. Now, there are some things happening in a venue we call the General Assembly. And we know that nobody is safe while the General Assembly is in session, because anything can happen.
What does that mean? Nobody is safe.
I love that.
This is a safe country, isn't it?
Not when the General Assembly is in session, because things can happen. And if you're a good individual, productive individual, you're probably working, so you don't have time to sit down and write letters and phone calls and emails and so forth to your representative, and so they can just pass stuff like crazy. And I feel sorry for these people that live a long ways away from the General Assembly, because the laws that they pass in the General Assembly are applicable to the four corners of the state.
And they're wide-ranging a lot of times.
Oh, yes.
For those who don't know, what is the General Assembly? Is that where everybody assembles, you and me and others, or what are you talking about?
It's made up of two houses.
Two houses?
One is the Senate, and one is the House of Representatives.
Oh, that's down at the Capitol, isn't it?
50 individuals have their desks in the Senate, and there's 100 have desks in the House of Representatives, and there are 50 senatorial districts, and within each senatorial district there are 2 House districts. So if you want to run for state representative, you'd better have some pretty good knuckles, because you're going to have to knock on a lot of doors and drum up a lot of votes. And you'd better have a pretty good pocket of money, too, because yard signs and so forth cost money, and commercials cost real big money. So this business of campaigning to be a state representative is a little bit different than it was in the initial stages of the Iowa General Assembly. It should be a good working environment. Their hours are really silly, and you certainly wouldn't want your public schools to operate on the same kind of hours that the General Assembly works, because they excuse their folks at 3 o'clock on Thursday afternoon, and say, we'll see you sometime afternoon on Monday. However, there's many a time, especially in the last 3 weeks of the session, they may go to 3 o'clock in the morning. Just one thing after another. Now, and they take up bills in the middle of the night that they know would cause the most frustration among the public, and for some reason there aren't a lot of members of the public there. 2 o'clock, 3 o'clock in the morning. I've sat through some of those sessions, and they can pull all kinds of shady things. I would hope that someday we could trust the people who are holding those positions. They're like the Department of Human Services. There are a lot of them who are not well equipped to handle the job. And it is a job primarily of compromise. They have to learn the art of compromise or they get nowhere. And sometimes I would find it very difficult in a certain bill where certain things have to be in place to compromise and say, well, I can give up on this and I'll support the bill if it doesn't have this in it, and so on and so forth. And first thing you know, you're back, in some cases, worse than when you started out. I heard of one fellow who submitted a bill, and by the time it got rewritten by the Legislative Service Bureau, it was so much different than what he had submitted that he voted against his own bill. So that's a pretty sad situation. At that time, when I was chucking in a few bills, or having some of the representatives and senators chucking in a few bills for us, I found out it would cost $800 per bill. So when you see these people looking over 1,500 bills, those bills, no matter how short they are, no matter how silly they are, they're costing the taxpayers, well, at that time, $800, and we could probably double that by now, because it is a costly thing to put a bill in the hopper and have it gone over very thoroughly. And it's probably a good idea that they comb these things very thoroughly by the Legislative Service Bureau. And those people in the LSB are very competent individuals. I don't know how they came out with a bill that couldn't be signed by the sponsor, but usually they're very competent individuals. They watch what they're doing, and some of them have enough seniority. They actually know what they're doing. Well, we've been talking about the 2,000-foot rule, and we've been saying how ridiculous it is to have a rule when there is no foreseeable use for the rule. In other words, the rule causes more problems than it solves, and it is a costly rule, the 2,000-foot rule, and it's not based upon any kind of science or any kind of a problem that they have to solve. All they know is that they don't like sexual offenders, and therefore they have to find some way of marking those sexual offenders and keeping them away from children, even though they recognize that the repeat rate, criminal repeat rate on these things. The reason I say repeat rate is because I don't know how to say recidivism. But the repeat rate on these things on these individuals, I believe, is somewhere around 3%. So let's take away the rights of the 97% and pass a 2,000-foot rule. So around 2002 or 2003, they passed the 2,000-foot rule. Went through court battles. It was struck down at one point. And then put back into place, I think it was in 2005 or 2006, and it has caused an enormous disruption in the lives of many individuals to have a 2,000-foot rule. Well, now they're considering chucking the 2,000-foot rule, replacing it with something that's probably equally dumb. In order to have what they call safe zones, that is, to keep these individuals, we call them scarlet letter individuals, away from schools and daycare centers, we'll just pass a law that says they can't come to those centers. Now, the rule would have to have 1,000 exceptions, and in order for a person not to get picked up means that he would have to stay away unless he has written permission from the principal or from the director of the daycare center to come on board for such things as voting, or if there's a dance at the elementary school, or if they are sent over to pick up the neighbor's kids because he wants to do a favor for the neighbor. Sorry about that. He has to have a written rule, a written permission from that. How would he get written permission from the elementary school to pick up the children? Would the principal fax it to him? How many people have fax machines? How would he get that in his hands without going to the principal's office and getting it in his hands? While he's going from his car in the parking lot to the principal's office, he'd be in violation. If he didn't get the piece of paper he needed, he'd be jailed. Well, I'm going to have Don read a story here in just a moment about how that silly thing works. It's another opportunity for them to try to punch at a problem without doing any thinking up front. The story goes like this. The House Public Safety Committee passed a bill unanimously on Tuesday that would prohibit sex offenders from entering safe zones surrounding schools and child care centers. Still undecided is whether the lawmakers will add language that would repeal Iowa's 2,000-foot rule affecting where offenders live, sex offenders live. State Representative Kurt Swaim, of Democrat of Bloomfield, said the House Study Bill 10 changes the focus from where sex offenders live to where sex offenders go. Well, say the 97% 3% rule still is in effect here. We're going to inundate somebody with all kinds of silly rules when 3% of the people may be causing the fear. And by the way, how many of these offenses take place in a public place like an elementary school or a middle school? Unless it's the teacher perpetrating sexual abuse on the children. We've heard of several cases like that. Are they going to keep the teachers away from the children? They should, shouldn't they? If any teacher violates any sexual offense law, we probably ought to keep the teachers 1,000 foot away from the children. I don't know how they're going to put together a good law like that. Unless registered sex offenders seek prior permission from the school administrators, they would only be allowed to go near schools if they are dropping off or picking up their children. You couldn't pick up your neighbor's children, of course. Attending a parent-teacher conference or voting. A House Senate subcommittee is expected to amend the bill, and language could include a repeal of the law that took effect in mid-2005, prohibiting sex offenders from living within 2,000 feet of schools and child care centers. The ultimate goal of the final bill will be to make existing legislation smarter and tougher, said Cleo Bowdler, Republican of Greenfield. Don, would you read that bill? It's a fairly short bill, but it'll give some of the details of how Iowa intends to make sure that children are safe in their schools. It doesn't say anything about being safe from their teachers, but being safe from parents of other children in the school. Don?
I got a couple comments. If this rule is 2,000-foot rule is rolled back, and in the meantime they've been throwing sex offenders back into prison for breaking that rule, haven't they, John? That would open up a lot of
That's correct.
lawsuits. And didn't you just get a call a couple days ago where a person had no knowledge of the law and got thrown into
Right.
prison?
Right.
He moved from another state, into Des Moines, and him and his family, and by moving to Des Moines, the nice place of Des Moines, he got thrown in prison. Okay, I'll read this bill for you. It first starts out, a bill for an act restricting the presence of a registered sex offender on the real property comprising a school or child care facility and providing a penalty. A person required to register under this chapter who has been convicted of a criminal offense against a minor or an offense involving a minor that is an aggravated offense, sexually violent offense, or other relevant offense shall not be knowingly present on the real property comprising a public or non-public elementary or secondary school or child care facility, unless subsequent apply. A. The person is transporting a minor who is a child of the person who is a child of the person to who or from the school. Let me read that over again. The person is transporting a minor who is a child of the person to or from the school or child care facility. I'm sure glad they've got legislators there can comprehend English, French, German, and everything else, so we can get some good laws passed. B. The person is attending a parent-teacher conference regarding a minor who is a child of the person. The person has been summoned to discuss the academic or social progress of a minor who is a child of the person. Well, at least they call them persons, don't they?
Right.
They don't lower them to maybe dog status. The person who is voting at the school or child care facility during the hours designated to vote. Number 2, if the person intends to be present for any other reason not enumerated in subsection 1, the person shall first notify the administrative offices of the public or non-public elementary or secondary school or child care facility that the person intends to be present on the real property comprising the school or child care facility. That would be like parent-teachers conferences, wouldn't it?
That's right.
They'd be on the school grounds.
And if you were in that category and they wanted you to mow the grass at the ball diamond because the kids are going to play the next day, that's the real property of the school, so you couldn't go and mow the grass.
Correct. And the person shall receive written permission from the school or child care facility prior to entering onto the real property comprising the school or child care facility. 3.
And how would you get the written permission?
From a person that
You'd walk to the office to get it, wouldn't you?
From a person that is antagonistic of this person,
Yeah.
so you wouldn't get it then. Conflict of interest. Number 3, a person who commits a violation of this section commits an aggravated misdemeanor. Is that like you get 30 days in jail or something?
No, that's 2 years.
Oh, 2 years.
Yeah.
Okay.
Right, Terrance? Aggravated misdemeanor.
Okay. Now,
You knew that lady Meaner, didn't you? Misdemeanor.
That's a good one. I haven't heard that one before.
now they give us an explanation for those who can't understand the English written by whoever writes the bill. So they make an explanation. And I remember 20 years ago reading a bill, and the explanation was totally different than what the bill said. So if the average legislator doesn't have time to read the bill and he just reads the explanation, he'll vote for the explanation. And in reality, he puts in a bill or votes against a bill that maybe he should have voted for. Or who knows? It's sure a mixed up system, and you'd think they'd be a little smarter down there. Explanation. This bill restricts the presence of a registered sex offender on or near the real property comprising a school or child care facility. The bill provides that a registered sex offender who has been convicted of a criminal offense against a minor or an offense involving a minor that is an aggravated offense, sexually violent offense, or other relevant offense, shall not be present on the real property comprising a public or non-public elementary or secondary school or child care facility. However, and I can just imagine the school if they have a request from somebody that they want to enter the school property, they could say, oh, there's a bill against it. But until they read the details, they don't know whether it applies to the person or not. It gets so complicated that just an opinion is not enough of an interpretation. You have to hire an attorney to interpret the law.
What if they don't answer the phone?
Well, sorry, you'll have to wait until they come back from vacation. And if they lie to you, well, that's tough luck for you too. However, the bill provides exceptions. One, a sex offender may be present on school or child care facility property if the sex offender is transporting the offender's child to or from school or a child care facility. The offender is attending a parent-teachers conference. The sex offender is summoned to discuss the academic or social progress of the offender's child. Hey, that's another way to throw them in prison. Somebody could call them up and say, come to the school, and supposedly it'd be okay. Somebody else sees them come to the school, calls the authorities, and off they go to prison. That's a scary situation those people are in. And some of them are totally innocent and have to go through all this nightmare. It goes on here. Or the sex offender is voting in an election during the designated hours to vote. If a sex offender is to be present on the real property of a school or child care facility for any other reason, the sex offender must first receive written permission from the administration of the school or child care facility prior to entering onto the property. A person who violates the bill commits an aggravated misdemeanor. An aggravated misdemeanor, here's where it tells us the penalty, is punishable by confinement for no more than 2 years, or in other words, they can confine them up to 2 years, and a fine of at least $625, but not more than $6,250. And so they can only hold them 2 years. They step out of prison and step across the line, and they go back to prison for 2 more years. It's a really scary deal for them. The bill may include a state mandate as defined in Code Section 25B3. The bill makes inapplicable Code Section 25B2, Section 3, which would relieve the political subdivision from complying with a state mandate if funding for the cost of the state mandate is not provided or specified. Therefore, political subdivisions are required to comply with any state mandate included in the bill. Now, John, I just read you this explanation. Was the explanation all in the bill, or
No,
is that open to debate?
no. The explanations are never become a part of the bill. They are always attached to the proposed portion of the proposed law, and they disappear when it actually goes into law. You don't see it on any document afterwards. It's only there to give some kind of a hint to the legislators as to what they're voting for. And I'm glad that they put in the penalty there, 2 years confinement, simply because you went to vote on the wrong day. 2 years confinement because it wasn't your child that you picked up when the child was sick. It was your neighbor's child, and there was nobody there to watch your neighbor's child. So even though you're a good citizen and you're among the 97 that will not reoffend, they're going to impose all kinds of problems on you. And if you ever got caught taking your neighbor's kid home and providing a place for that person to be safe while they wait for mother to come home from work, it could cost you 2 years in prison. Doesn't make a whole lot of sense to me. People that can't behave need to be imprisoned. Once they've served their time, they need to be trusted enough to run free and not have to get notes from their principal for this and for that. Some of the workings of this would be very difficult. Before we go too far, run out of time here. Later on, time permitting, I want to talk a little bit about child abuse facts from the Iowa Department of Human Services. That's where I learned that there's 214 ticket writers. Their job is to do nothing more than to write assessments. There is no other task that I know of in state government other than perhaps state troopers. I don't know how many state troopers we have, but no other statewide job that I know of that has that large of a task force. Maybe Department of Homeland Security will get there someday to have a massive force. But right now, the DHS, that is Department of Human Services, has 214 people whose job description is precisely the same: protecting children and writing assessments that bug people. So we'll talk about that a little bit. But before we do that, we're going to take some time out here to switch to someone who has worked a lot looking over the affairs of government as they pertain to the judicial system. And in order for us to do a good job of this, we turn to an individual who is knowledgeable and handles these things in a professional fashion. That person is Terrance Walker.
Thanks, John. Well, got to say that, you always give me the great introductions, but you guys are icons here in the state of Iowa, I think, and now in Omaha, Nebraska, and surrounding counties as well, by your work in exposing faults with child protection policies. I have some interesting news here from, it was a press release from February 21st. It's a little dated, but I haven't been on the show in a couple weeks. So I thought I would share this with you because I think it's of unprecedented. It's an unprecedented step by any organization. The Judicial Accountability Initiative Law, jail for short, is something that's been pressed upon in the state of South Dakota this past year, and it's also being pressed right now in the state of Florida. And the Judicial Accountability Law basically is supposed to set up special grand juries to investigate and operate as a check against judicial misconduct and abuse of power. Now, they just released a press release on the 21st of February. The Florida Jail Organization has basically stated in this press release that Florida Jail for Judges today filed in the Florida Supreme Court a petition enjoining the Florida Bar from engaging in activities related to the drive by Florida Jail for Judges to amend the Florida Constitution. Now, the Florida Jail for Judges seeks to amend the Florida Constitution by an amendment that would be a check against judicial misconduct and abuse of power. The Judicial Accountability Law creates 2 statewide special grand juries in Florida for the sole purpose of investigating complaints against judges. The special grand juries will have the power to sanction judges by levying fines and forfeitures against them, and for third-time offenses, removing them from the bench. The special grand juries will also have the power to indict judges and subject them to criminal proceedings before special trial juries who may sentence them as well as convict the offending judge. And what's unprecedented is the Florida Jail Organization filed suit against the Florida Bar. The suit against the Florida Bar makes 4 claims. First, that the people never delegated to the judiciary the right to set up a mandatory bar, which acts as the, quote, arm of the Florida Supreme Court, engaging on behalf of the Florida Supreme Court in political activities that the Florida Supreme Court is barred from engaging in. Second, given the monolithic prestige, power, and purse of the Florida Bar, it has confiscated the quote-unquote marketplace of ideas to such an extent as to deny citizens of the state the fundamental right to petition for redress of grievances. Third, it is unethical for the Florida Supreme Court's arm to engage in political activity when the justices of the Florida Supreme Court cannot engage in that same activity. Last, Florida Jail for Judges has alleged that the Florida Bar is violating Chapter 106 of the Florida statutes by engaging in political activity without registering with the Department of Elections and reporting its expenditures. The lawsuit is in its entirety as posted in a PDF file on the website. Actually, it's on the www.jail, the number 4, and then judges.org. Very interesting lawsuit because, for one, they're suing they're basically entering a lawsuit against the Florida Bar. Then, what else I find kind of entertaining is that they also filed a motion to disqualify all of the judges on the Supreme Court. So here you have a suit filed against the Florida Bar, which the Supreme Court is they're the arm of the bar, basically, or the bar is supposed to be an arm of the Florida Supreme Court. But then you have another motion which is going to remove, if it was successful, remove all the Supreme Court members off of the bench. You think that's interesting, John? Pretty interesting. Pretty clever, because if it wasn't for the bar in the state of South Dakota, this measure, similar measure, would have passed in the state of South Dakota, because it was the bar in South Dakota, for the most part, that was actually advocating the defeat of
The
jail
bar
for
wanted
judges.
to bar it, didn't they?
The bar wanted to get rid of it because they felt it wasn't a good mix. They wanted to maintain all of the say-so and the power on these cases, and they don't want citizens like you and I and the common folk come along and changing things. They want to keep everything status quo as it is. Well, status quo doesn't work all the time, and that's why we don't have a judicial qualifications commission that's working. You know, how many judges have they ousted in the past 30, 40 years since they've been operating? 3?
Yeah, right.
You know, come on. I mean, we can't say, I mean, I've been in courts and you guys have been in courts. I can't say that our judges are that great that we could only remove 3 of them in almost 40 years. Come on, they're not doing their job. The federal commission that investigates judges is even worse, because, you know, out of what, think about almost 200 complaints, they dismiss all of them except for one, and they have a private reprimand on that one. So, I mean, you know, this is why we have these things come about, because people feel that these bodies are not doing their job to wean out the bad apples. So when you have a bad apple in the bunch, what happens? It makes the whole bunch bad. So that's why we have these measures like jail for judges. And I think it's admirable that they're trying to get rid of all the bad apples, because there's a lot of them out there. But one of the things I think that's also that stands out, and they point to, and I think that the court's going to have a hard time getting around this. One of the arguments that was made in this petition, well, first of all, let me lay forth what they specifically asked for in this petition. They asked to amend the Florida Constitution as detailed, and they're enjoining the Florida Bar from involving itself in the political activities related to this amendment. And then they want to also, in this suit, direct the Florida Bar to give equal space in its publications to re-level the playing field skewed by the Florida Bar's present reporting on Florida Jail for Judges, and require the Florida Bar to register as a political action committee with the Division of Elections. One of the arguments I think they're going to have a hard time getting around in the Florida Supreme Court is the fact that the Florida Bar is connected with the Florida Supreme Court, and as thus, being that under one canon of the judicial conduct of Florida prohibits political activity. Well, they're engaging in political activity through this arm, and they even define the Florida bar as its arm in their own literature, on their own rules. So that's one argument I think they're going to have a hard time getting around. But, we know how courts and lawyers sometimes know how to split hairs. So, we may see something, well, it's not really our arm, it's somebody else's arm. So that's what you're going to see in that motion. I'm sure you've probably seen that in some legal filings as well, some nonsensical hair splitting in the court case or two. But some other precedent, I think, that they're going to really have a hard time getting around. I mean, one other argument I think they're going to have a really hard time getting around with also is the fact that this Florida bar somehow, through its membership, they distribute 80,000 plus magazines or periodicals to all these members on a regular basis. Well, we've got the supposed arm of the Florida Supreme Court is supposed to act only in the regulation matters as it pertains to the membership of the attorney. It's supposed to be a limited. The Florida bar is supposed to have a limited grant of regulating attorney admission and discipline to inculcate its members the principles of duty and service to the public, to improve the administration of justice, and to advance the science of jurisprudence. Now, what they've done, though, however, is even beyond that. And this petition does a really good job setting it forth on what the Florida bar is doing in its publication. They're disseminating all these negative articles about jail for judges and advocating on no uncertain terms that the jail initiative should be basically defeated.
So they're doing the same thing as happened in South Dakota, basically.
Yes, exactly. And so what I think is admirable is that the Florida Jail for Judges organization, seeing this as a potential problem, and they were proactive about it and taking the first steps to try to stem the judiciary and its arm, the Florida bar, from trying to defeat the passage of a measure which would negatively impact I think it would positively impact the judiciary. But if they're in the judicial realm and the legal realm, and
right.
they like the status quo, I guess they would consider it to be negatively impacting their profession or their industry, if whatever you want to call it. But yeah, that's my little 2 cents on what I feel is important in the world of the judiciary. And I think we should definitely pay heed to what's going on there, and hopefully we'll have some measure like that going on here in the state of Iowa.
We happen to know that our attention to the courts is extremely important, because no matter how much we do to straighten up the executive branch of government, which includes the Department of Human Services, there'll be no great improvement in the way things go until the courts behave themselves, because the courts can undo everything that we've done. Well, I mentioned to you earlier that I wanted to go down some of the figures that the Department of Human Services has given to us. Here are some of those. Well, I can't make it sit up right. Okay. May have to hold it there. I don't know. We're having some curling problems here. Okay. First of all, these are overall figures for the entire state of Iowa, and they break them down into counties, but we won't have time to go the county route right now. 13,000 children, they say, were abused or neglected in 2006, down 4%. Isn't that terrible that they've got a drop here? That means we may need fewer social workers. I wonder if they look at it that way, from the previous high of 13,544. 77% of the abuse falls under the category of denial of critical care. You know why that is? Because the definitions are anything they want to make them. So if you leave your 17-year-old in the car while you take the bottles in for deposit, that is denial of critical care because your 17-year-old needs supervision. He does. You're probably better off in the car. Of the abused children, half are age 5 or younger. 77% of them fall in the category of denial of critical care or neglect. 24,789 child abuse assessments were made in 2006, an 8% decline compared to 2005. Isn't it a shame that these declines are happening? Because it means that we'll need fewer social workers. I think that is what I'm reading into these figures. 11,000 complaints of abuse did not meet the legal threshold. Well, you see, they're not bothering to educate the public like they could if they had a centralized intake unit like I've advised and like the state ombudsman has advised. And they have $390,000 put aside for implementing that, but they're not going to spend it on such things as centralized intake to lower these figures. 9,257 founded or confirmed cases of abuse compared to 9,900 in 2005. Maybe they're figuring out that it doesn't pay to rat on your neighbor just to make some kind of a headway. Well, those are some of the figures. We'll work with those, try to give you a little more information about those as time goes on. We're really pleased to be able to bring you some of this information into the homes of families in central Iowa, and sometimes even into the Omaha Council Bluffs area. We're appreciative of your phone calls, and here's some numbers that may be helpful to you as you have struggles with the Department of Human Services. We're not attorneys, but we can give you some assistance in the way that you look at the paperwork and the way that you deal with the Department of Human Services. There are a few good people in that department, and we don't mind advising you as to people that you should be talking to in the Department of Human Services. We're most appreciative of your letting us into your living room to talk about child abuse issues in Iowa. We'll see you next week.